Attorney Jaffe, are you ready?
I'm sorry, Your Honor. Yes, I'm ready. I have technical difficulties. My apologies.
Recall Gray.
Calling case 240556780 The people of the state of Michigan versus Walter Gray. Defendant is charged with count 1, homicide, murder, second degree. Count 2, weapons, felony, firearm. Today it is date and time set for bond redetermination. Appearances, please.
Jennifer Douglas for the people, P72748.
And good morning again to the court, Your Honor. Attorney Brent Jaffe, P81818, retained counsel on behalf of Walter Gray.
My understanding that Mr. Gray is not going to be presented today based on a personal safety issue at this time.
Yeah, correct, Your Honor. I did hear that as well from the clerk. So I guess at this point, I'm not sure if I have any leg to stand on in terms of a bond reduction. If I do, I'd be asking for a reduction.
Okay. Well, I mean, you can make an argument.
Yeah, sure. Thank you, Your Honor. I would just say, Your Honor, Mr. Gray, he's 22 years old, no prior criminal history, a tremendous amount of family support, and again, presumption of innocence, Your Honor, and retained counsel. I've spoken with Mr. Gray on numerous occasions, from the time he's been charged until really most recently, yesterday. And Your Honor, I guess we're asking that Your Honor consider a reduction in bond, and then again, taking into consideration the presumption of innocence, Your Honor, because I do think that from what I know about this case, it's a very triable case on behalf of my client. So for those reasons, Your Honor.
Court haven't heard the argument of counsel. Court finds the $750,000 bond is an unaffordable bond. In order to have an unaffordable bond, there has to be a showing by clear and convincing evidence that the defendant is a danger to the community, the complaining witness, or flight risk. In this matter, the allegations of second-degree murder obviously poses a danger to the community, not to the complaining witness, because the witness is deceased. Court finds the $750,000 bond is an appropriate bond. Bond will continue.
Thank you, Your Honor. And is Madam Prosecutor, is that the prosecutor that's the prosecutor of record, or just for your courtroom?
I'm just here for today.
Oh, okay, thank you. I'll see the discovery. Okay, thank you very much.
Calling case 24055499901 The people of the state of Michigan versus Brandon Miller. Defendant is charged with count 1, assault with intent to do great bodily harm, less than murder, or by strangulation. Count 2, assault, aggravated. Habitual offender, fourth offense notice. Today is the date and time set for bond redetermination. Appearances, please.
Jennifer Douglas for the people, P72748.
You got to break it on behalf of Brandon Miller, who's appearing via Zoom. Mr. Miller, can you please raise your hand?
Okay. One moment, please.
Mr. Todd Thomas, you're all set.
Oh, okay.
No problem.
Thank you.
You're welcome.
One second. One second. Mr. Reagan.
Judge, this is a case, I'm simply just asking for a small reduction, some type of cash bond. My client's in the MDOC. He's going to be there for a while. His bond's $300,000 cash. I just think that's a little excessive. So I'm just asking for a small reduction, Judge, some type of non-bond.
Miss Dutch.
Your Honor, he is in MDOC. However, if we look at the allegations, considered priors, we do think he's a danger. I mean, we're not anticipating him getting out. We just don't see a rationale for reducing it.
Okay, when is his out date from MDLC?
He's currently serving 2 to 10, 12 to 25, Your Honor.
Um, we would point out that oh, sorry.
What?
No, I was just gonna point out that with Mr. Miller, the alleged assault happened relatively recently to when he was supposed to be in prison, Your Honor, and then that's what gives us concern about his danger to the public.
He's going to be in prison for next year. So and
Bond is reduced to the amount of 30,000, 10%.
thank you, Judge.
And a no contact provision with the complaining witness.
Yeah.
Thank you.
Okay, Mr. Miller, you're all set.
Calling case 24055644401. The people of the state of Michigan versus Messiah Emerson. Defendant is charged with count 1, weapons, firearm, discharge in or at a building causing injury. Count 2, assault with intent to do great bodily harm, less than murder, or by strangulation. Count 3, weapons, dangerous weapons, carrying with unlawfully intent. Count 4, assault with a dangerous weapon, felonious assault. Counts 5 through 8, weapons, felony, firearm, habitual offender, second offense notice. Today is the date and time set for bond redetermination. Appearances, please.
Jennifer Douglas for the people, P72748.
May it please the court, Your Honor, breaking on behalf of Mr. Emerson, who's appearing via Zoom for bond redetermination.
Emerson. What's Mr. Emerson's bond?
300,000 cash surety, GPS tether, house arrest.
Argument.
Judge, he's 36. I'm not seeing, Judge, and I can be wrong, any assaultive history. He's on probation right now, non-reporting probation to Macomb County for a non-assaultive property crime, Judge. He has 6 children. He works every day, does home health care, makes a living, supports his kids. Judge, obviously 8 counts is a lot of counts, but I'm asking the court respectfully reduce the bond. He has a lot of medical issues. He says that he's due to have brain surgery very soon as well, Judge. The complaining witness is a person at the gas station. So I'm asking the court to consider personal bond, GPS tether, house arrest, medical only, that he can go to his medical appointments and deal with those medical appointments, Your Honor. I don't see any, like I said, any assaultive history, just some theft crimes. And again, he's on a non-reporting probation to Macomb right now.
Argument.
Your Honor, we're asking for that bond to stay the same. This is highly assaultive. There's a lack of provocation that involves a firearm. We do think he's a danger to the public. We would point out that Mr. Emerson was actually supposed to be getting arraigned last week on a different case, including a refusal to fingerprint. This was the second time of trying to arraign him on that. He would not cooperate with getting arraigned. And if I remember correctly, he actually tried to spit on the deputies at some point. Your Honor, we have concern in that him refusing to get fingerprinted indicates that he will not appear for court as required if he can't even comply with that. So, Your Honor, given the violent nature of the accusation, given that he would not even cooperate with getting fingerprinted, or last week when he was supposed to be getting arraigned, we do have concern for the public and him complying with restrictions, even if he does have a tether on, because that won't keep him from going anywhere. It'll just alert if he goes someplace. So we're asking for that bond to stay the same.
Judge, I don't have any knowledge about him not fingerprinting. I don't know about that part. I can say that he is in, and he's here, charged. He got cases.
You can look it up. The date of offense is February 7th. Oh, sorry.
It's okay, Ms. Douglas. Court haven't heard the arguments of counsel. We have before us a defendant who's currently on probation, who's alleged to have walked into a gas station and pistol whipped someone in a gas station and shot them in the foot. I I don't really understand the fact pattern.
More to it.
Yeah, I don't understand the fact pattern. But what I do know is that, we do need to be on our best behavior when we're on probation and go through our conditions and do all that stuff. And pistol whipping, having firearms, I'm sure is not part of anyone's probation that you get to have firearms, whether you pistol whip someone with provocation or self-defense, or you don't pistol whip someone. It's just it's a lot here. Court haven't heard the arguments of counsel. Court finds a $300,000 cash bond is an unaffordable bond. Court finds that in order to have an unaffordable bond, there has to be showing by clear and convincing evidence that the defendant is a danger to the community, the complaining witness, or a flight risk. Ms. Douglas is arguing he's refusing to be fingerprinted. That shows a possible flight risk. I don't have any evidence of that, but the fact that he would allegedly pistol whip someone in a gas station on video makes it seem it's a little bit dangerous. That being said, court's going to reduce the bond to $300,000, 10%, with GPS tether, house arrest, and he can leave for medical appointments and court appearances only, and a no contact with the complaining witness. Thank you.
Thank you.
And Your Honor, just for the record, that failure to that refusal to fingerprint is actually charged.
Okay.
And he was supposed to be arraigned on that last week, but he wouldn't cooperate.
Okay. Got it.
Okay,
Thank
Mr.
you.
Emerson, you're all set. Thank you. You're all set. Hi, your name?
Ikea Boykin.
Calling case 24055670001. The people of the state of Michigan versus Shakia Boyd. Defendant is charged with count 1, assault with intent to do great bodily harm, less than murder, or by strangulation. Count 2, stalking, aggravated, habitual offender, fourth offender's notice. Today is the date and time set for bond redetermination. Appearances, please.
Jennifer Douglas for the people, P72748.
Reagan on behalf of Ms. Boykin, Your Honor.
Argument.
Judge, Ms. Boykin's 37. She does have some priors. She's a lifetime resident of this area. Judge lives in the city, has strong ties to the city. Not working right now. Judge does suffer from some medical and or mental conditions, Your Honor. This particular case, Judge, this comes down to an identification thing, I think, judges. There's no video about this. You have one witness says one thing, another witness that may say something else. My client professes her innocence, says she never touched him at all. So obviously this is a case that's going to have to matriculate. The bond is $30,000 cash, GPS tether, house arrest. It is unaffordable. I think the court could, in this particular case, keep the complaining witness safe by issuing the tether with the house arrest. But I think a personal bond could suffice in this particular case, Judge.
And the bond is 300,000?
30,000 cash.
30,000.
Cash.
All right, continue.
So I'm asking for a reduction of 30,000 personal GPS tether house arrest.
Ms. Douglas.
Your Honor, we're asking for that bond to stay the same. We don't believe that this is a identity issue. Ms. Boykin was still there at the location when the police responded. So it's not just somebody saying one thing, maybe somebody else is saying something else. Also, there was a PPO involved here. So the victim does know who she is. The PPO was served November 7th of last year. She wasn't supposed to be at that location or by the complaining witness. And so, Your Honor, considering that the complaining witness is in his 70s, she does have prior assaultive convictions, a 2005 felonious assault, a 2014 felonious assault. And considering that somebody else, not just the complaining witness, says that she pushed him into the street as somebody in their 70s, 79. Your Honor, we do think that there's a danger there. Seeing as how a PPO has allegedly not protected the complaining witness, we don't see why a court order by itself is going to protect him. There's also, I saw on the website that there's actually a pending case, the case number 230599797. I don't know why she wasn't arraigned on it. It's showing it was authorized November 6th of 23, although the date of offense is listed as August 17th. And that's a FA. So I'm not sure why she wasn't arraigned on that yet. But Your Honor, she has history of assaultive contact. And she's accused of that here, and she was actually still there when the police showed up. So we do think there's a danger if she will allegedly not comply with the PPO.
And Judge, I don't know the history of it. I know it seems like a strange relationship. I don't know what the real relationship is between the complainant and my client. I don't think that there is a romantic relationship. It's a little bit odd, but again, Judge, I don't know about a PPO. I don't know the history of that. I don't know if it was a situation where he was allowing her to come back around or telling her to come back, or they were dealing with business issues or whatever. But I just think the court in this case could make the complaint safe by issuing a tether and house arrest.
Court haven't heard the arguments of counsel. Court finds for $30,000 cash bond is non-affordable bond. Bond is going to be reduced to $30,000 personal. House arrest, medical appointments, court appearances only for release. The no contact provision will continue. Thank you.
Thank you.
What's gonna happen?
I'm gonna tell you, Miss Boykin.
When is her next court date? When is her next court date?
1 second.
February 20th, 2024.
In front of
Sabri.
Okay. You're in front of Judge Sabri on one more time.
February 20th.
February 20th at 8:30. Okay. All right. Thank you.
Thank you, man.
You're all set, Ms.
What's gonna
Boykins.
happen?
You're gonna get a tether. You're gonna get a tether. You gotta stay in the house, Miss Boykin. You can't leave the house, okay? Once you get the tether, you're gonna release and get a tether. Go home and you gotta stay in the house, okay?
So it'll be a few days so I can get a tether.
Probably, yes.
Okay, well, like the thing with the tether, like y'all just be putting like anybody's fucking address. Like, can y'all give me time to find out whose address I'm gonna use?
Yes.
Well, yeah, you have to give them an address. Somebody's who you want, where you're gonna be. You give them the address.
Okay.
You give them the address, okay? All right, Miss Boykin. Take care.
You know how y'all be with that stuff, Phil. Just
I'm sorry.
You know how you guys get.
Right.
Get,
just any address. Yeah, anybody.
Just.